Welcome back everybody to the Law of Tort. In this video what we're going to be doing is talking about the concept of negligent misstatement, which relates tangentially to the concept of pure economic loss and consequential economic loss. We'll take an introduction to negligent misstatement in this video, and then we'll talk about some of the implications of negligent misstatement in the next few lessons as well. So far, we've been discussing the nature of pure economic loss, as well as the distinction that is often made between pure and consequential economic loss, noting that there is actually quite a difficult delineation to be made between these two concepts. In this lesson, like I said, we're going to start to look at the concept of negligent misstatement in more detail. So, the question for us today is essentially, what is negligent misstatement? What do we mean when we talk about negligent misstatement? Well, what negligent misstatement refers to is a situation where a defendant negligently will make a claim or a statement to a defendant, and then for that defendant to then rely upon that statement in which the falsehood leads to a pure economic loss. So, for example, if I rely on somebody's statement when I make a claim, and my reliance on this statement is pending on money that I put down, or potentially a loss of money if that statement is wrong, and the defendant has been negligent in making this claim and this statement, and it turns out to actually be false, then, and as a result of which I suffer some kind of economic loss, then this would represent a type of negligent misstatement. While the general rule is that there is no valid claim for pure economic loss, generally speaking, the concept of negligent misstatement represents something of an exception to this rule, because in reality, negligent misstatement represents a pure economic loss. It is an economic loss on the basis of a false claim that is made, but it is still a valid claim within the law of tort. The case of Hedley, Byrne and Heller from 1964 is the case where we discuss negligent misstatement in more detail. In this case, you have the claimants. The claimants were an advertising agency. They essentially wanted to see and inquire about a potential client, and the potential client was Easy Power, and so as a result of which they wanted to know if their potential client was credit worthy. I.e., would they be able to pay their dues, or were they essentially a good client to have as an advertising agency? Would they make the advertising agency any kind of money? They tried to get information about the potential creditworthiness of the Easy Power company from the bank of the client, from the bank of Easy Power, and so as a result of which the bank were the defendants. The bank would then respond by saying that the Easy Power company had favorable credit reference. They had favorable credit, and this incentivized the claimants to enter into a contract with Easy Power and take them on as a client as part of their advertising agency. When the Easy Power company then went into liquidation a few months later, the claimants lost around £15,000. They then sued the bank for negligence in terms of the statements that they had made, for negligent misstatement. It was held that the defendant was not liable in negligence, but it's a little bit more complicated than this, because they were not liable in negligence as the result of one particular action that the bank did, but if they had not performed this action, they would have actually been liable in negligence. The reason why they were not liable in negligence was because when the bank had been approached for this information, upon request for the information about the creditworthiness, the bank actually included a disclaimer that said, quote, "for your private use and without responsibility on the part of this bank or its officials." This represents a disclaimer. They essentially said, this is the information that we have upon on the idea of this company's creditworthiness, but we do not take responsibility for any of the things that you do in response to and upon given this information. The argument that the House of Lords presented was that essentially, but for the issuance of this disclaimer, the bank would have actually been negligent for a statement made. So all the parts, all of the key components of negligent misstatement existed in this case. They were all present in this case. The only thing that stopped them from being liable in tort was the fact that they had issued a disclaimer. Now, today, with statutory regulation and consumer protection legislation, disclaimers like this wouldn't have been as as strong in terms of the protections that they give, but at least at the time, they worked particularly well. And so essentially what we have here is the establishment of a negligent misstatement and all the key component parts of the negligent misstatement, despite the fact that the claimants were, the defendants, were found to have been not liable in the law of tort, owing to a particular niche element of the case. What is interesting here is it essentially delineates from the principles that we see when we look at the duty of care, i.e. the case of Donahue and Stevenson, because in addition to these principles, it is recognized that the concept of proximity that we see in other duty of care cases, in other negligence cases, this idea of proximity can be translated in these kinds of cases to include issues where there is a special relationship that is established between the claimant and the defendant. And so all of these issues are raised and discussed, but they it doesn't mean they don't apply to the case of Hedley-Byrne. The only thing that is different about Hedley-Byrne is the issuance of this disclaimer that existed. And so a special relationship standard can exist between a claimant and a defendant such that a negligent misstatement can actually give rise to liability, and so really represents a pure economic loss and an exception to the general rule that pure economic loss does not often give us a valid claim. So in the previous lesson, we introduced the subject of negligent misstatement as part of the law of tort, representing something of an exception to the general rule of pure economic loss, i.e. the general rule of pure economic loss is that there is no valid claim for a claimant. There has to be some kind of consequential economic loss in order for a claim to be successful. Well, negligent misstatement as a result of the case of Hedley-Byrne and Heller shows us that this is something of an exception to the rule of pure economic loss. This video is going to talk about the development of the doctrine of negligent misstatement, talking about how it has been applied in the case law more subsequent to the Hedley-Byrne principle. And we'll talk a little bit more about the development in case law subsequent to that, and talk about some of the key elements that are required to show successfully a case of negligent misstatement. So let's just recap very quickly the Hedley-Byrne and Heller principle. The case of Hedley-Byrne and Heller establishes that a duty of care can exist between a claimant and a defendant where there is this special relationship that exists. This special relationship seems to require, according to the case law, that the claimant used the information provided by the defendant to make decisions. This case specifically was a case of an advertising corporation wanting to know about the creditworthiness of a bank. The creditworthiness of a client, and therefore went to a bank to obtain that information. When the company then went into liquidation and the advertising company lost thousands of pounds, they sued the bank for negligent misstatement for negligently providing false information about this corporation. Now, the defendant should also have included in this knowledge of, or ought to have had knowledge of, the fact that the claimant was going to rely on the information provided to them by themselves. So there has to be some indication that the claimant was going to use that information to make decisions which would result in some kind of loss, often lost to economic prosperity, essentially. And then finally, there has to be a reasonable understanding that the claimant relied on the information provided by the defendant. The case of Hedley-Byrne and Heller was a case where an advertising company relied on the information provided by the bank in order to make a decision about whether or not to take on this other company, the company Easy Power, as a client in the future. And so as a result of this, they relied on that information by the bank, and the bank ought to have reasonably known about that information. We remember that the only reason why the bank were not liable in this case was because they provided a disclaimer attached to the information. But this would be a disclaimer that wouldn't have as much weight in the law today, owing to things like the Consumer Protection Act and other kinds of consumer protection regulation. In 1990, we get the case of Smith and Bush. This case illustrates the imposition of statute in the establishment of a negligent misstatement, and specifically the idea of disclaimers placed upon them. Because ultimately, what the Hedley, Byrne and Heller rule tells us is that negligent misstatement can exist in all of these circumstances, but so long as you have a disclaimer that you place on the statement that you make, it can't therefore lead to you being held liable in the law of tort. Well, there had to have been a change to that problem, okay? Because in this case, the claimant had been in the process of purchasing a house, and they had obtained a mortgage with the bank for a property. The bank commissioned a surveyor to go and examine the property, as ordinarily would happen in any circumstance where you're buying a house. The report from the surveyor was made, and the claimant then purchased the property on the basis of that report, of the report made by the surveyor. So they relied on the information by the surveyor about the quality and the construction and the infrastructure of that particular house. It later transpired that the surveyor had been negligent in his actions and had failed to recognise quite a significant amount of subsidence that existed in the property, which would require extensive repairs. Those extensive repairs would obviously cost a lot of money that would come out of the pocket of the claimant. The defendant was the surveyor, and they argued that they had no liability, since they had issued the report with a disclaimer. So they were very similar to Hedley, Byrne and Heller, in the sense that they essentially didn't try and defend their actions. They didn't try and make a defense or mount a defense in terms of the negligent misstatement. They mounted the defense that they were not liable regardless of the negligent misstatement because of the fact that they had issued the statement with a disclaimer. So, and as you can understand here, you can see that they would have been liable. They would be liable in this case for negligent misstatement because they had negligently failed to recognise subsidence, which would require extensive repairs, costing the claimant a lot of money, and that this was information that the claimant relied upon in the purchase of the property itself. So, despite the fact that they said that, well, we have a disclaimer, and the Hedley-Byrne principle tells us that if you have a disclaimer, then you should be fine, the courts held that the defendant was actually liable. This was because the disclaimer represented an exclusion of liability clause. At least that's how the courts perceived and interpreted what this disclaimer essentially was. And so, according to the Unfair Contract Terms Act of 1977, an unreasonable exclusion of liability clause, a clause of this nature, would be void, and so as a result of which would have no binding authority. The disclaimer, therefore, would not have protected the defendant from any kind of liability in terms of negligent misstatement. Finally then, a few years later, we have the 1995 case of Hendon and Merrick Syndicates Limited. This case is fascinating since what it does is look at the question about whether or not there could be what are known as concurrent duties. So the facts of this case involve a number of managing agents of investments in a complex Lloyd's insurance syndicate. So ultimately, the Lloyd's insurance syndicates were very, very complicated. The facts of this case are particularly complicated. I'll try and give you as much the facts as possible without having to go into the weeds as to the specificities of the facts. So the investors were titled names and had a contractual relationship with the defendants, but there were also a number of issues relating mainly to this idea of contractual privity, owing to the imposition of third parties. We've talked about privity and in the relation to the law of contracts over on the lessons on the law of contracts, so I won't get into that in too much detail here. But the issue, therefore, meant that it would be difficult for claimants to make claims on the basis of a breach of contract, owing to the fact that there is this imposition of third parties, and we have to think about the concept of contractual privity. And so instead, they go and they turn to the law of tort to try and get remedy for their claims. The courts held that the defendants were liable in the law of tort. The courts held there was not some reason why, just because they were also linked contractually, and because there could have been claims in the law of contract, that there couldn't have been claims in a law of tort as well. And so in addition to this idea of the special relationship also was expanded to not just include the reliance of the specialized information by the claimants, but also the provision of services by the claimants. So we're not just talking about information that is relied upon, but also services which are relied upon. In this final lesson, talking about pure economic loss, and specifically within the context of pure economic loss, negligent misstatements, I just want to talk a little bit briefly about the concept of the application of negligent misstatements claims against that of third parties, or in relation to that of a third party. It's something of an interesting esoteric part of the law that I thought we should cover very quickly before we then move on to the next major chapter on negligence, which is, of course, the breach of a duty of care and the standard of care, before we then go on to looking at causation. So, like I said, this is the final lesson examining negligent misstatement. We're examining the concept of this misstatement, which is the result of the words of third parties. To what extent can we find successful claims for negligent misstatement as the result of the words of a third party? So, there are some cases in which the courts have recognized the existence of some kind of duty of care on the basis of negligent misstatement, but that is not done through the use of information, but when you are the subject of the information. Okay, so this is something and representative of something of a variation, a slight variation on the concept of negligent misstatement. If we remember back to Hedley-Burn and the case of Hedley-Burn and Heller, you'll recall that it was in this case the claimants had relied on information about the creditworthiness of a particular individual, more specifically a particular company, Easy Power. And what they had done, as a result of the information about the creditworthiness of this company that was provided by the defendant, the bank, they said, okay, we understand this information. We are going to change our behavior accordingly to represent on the basis of the information that we have been provided by this bank. Now, in the cases illustrated in this lesson, should I say, no such set of factual circumstances would exist. And so if we talk about the case, for example, of Spring and Guardian Assurance PLC from 1995, we see that in this case, the claimant had been the former employee of the defendant. When they sought to move into a different type of employment, they sought to move to a different job, what they did was they asked for a job reference. A job reference obviously is something that is required for pretty much every single job or every application of anything. And this former employer, the person who formerly employed the employee, had negligently written a job reference which would ultimately cause damage to the claimant's job prospect with a new employer. So they basically were damaged on the basis of the fact that the reference that was provided by the original employer had been negligent in the reference that had been established, negligently negative ultimately. As you can see here, the circumstances are quite different to that of the Hedley-Burn case. This was an example where the claimant was not relying on the negligent information, but they were relying on a different third party. The claimant had not altered his behavior either in response to this information, which was considered to be one of the important elements of the Hedley-Burn principle. And so, nevertheless, it was still held that the defendant was liable in tort for the negligent misstatement, owing to the fact that they had a duty of care based on the presumption of responsibility. There was a general presumption of responsibility on the part of the employer to provide a reference which would not have been negative, given the fact that it should have been done non-negligently. So it should have been a non-negligent reference that had been provided. This didn't happen in this case. In this case, instead, they had been negligent in providing that information. Similarly, in the case of White and Jones from that very same year, it was a case which involved the negligence of a third party, and that this negligence had an impact on that of the claimants. The claimants had been the supposed recipient of the will of their father, and the defendant was the solicitor of the father who had negligently reduced their entitlements to their father's will. And the court held again that this third-party negligent action had resulted in the bringing about of an assumption of responsibility. And so as a result of this, bringing about a duty of care. The duty of care could be justified in this case on the basis that the potential loss was foreseeable, in the sense that if I was negligent, I could foreseeably understand that the loss could exist, okay? And that the duty of care would be just, fair, and reasonable in the particular circumstances that were provided.